our Foreign Excellence webinar series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is a U.S.-based service provider offering IP docketing, paralegal, analytics, and annuity services. The SLW Institute is an educational group created by the Schwegman Lundberg Wissner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have brought together experts from the Schwegman firm, Black Hills IP, and their respective clients and customers to talk about strategies and best practices for patenting in key non-U.S. countries. The Foreign Excellence webinar series is free. This is the first of about 20 webinars that will be included in this series. The schedule and registration information for the first 10 of these webinars is listed on our website. To register for future programs, go to the tab for Educational Resources on the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today will cover China. We have allowed time for questions at the end of the program, but questions may be submitted throughout the program using the question button on the right-hand side of your browser window. You can submit a question at any time during the presentation, and it will be held in a queue until the end of the program. Before we begin, I want to let people know that Black Hills IP is presenting a free full-day docketing seminar in Washington, D.C. on November 8th. This is an advanced docketing seminar that is intended for people with, I'd say, 3 or more years experience in patent docketing, and will be beneficial even for your most experienced docketers in your organization, even the 20, 30-year docketers. To register for the seminar in DC, go to the Educational Resources tab again on our website, and then click on Seminars under the Docketing Excellence heading. We'd love it if you'd share this information with those in your docketing department. Presenters for today's program are myself, Rachel Hook, and Greg Stark. I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 20 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I was also a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center, which is now University of New Hampshire, for 5 years. Rachel, can you tell the audience about yourself?
Yes, certainly. It does seem a bit funny that I'm speaking on China when I'm actually from Australia, but I'm a partner of FB Rice. We're an IP firm which operates in Australia, New Zealand, and Southeast Asia. And while we don't have offices in China ourselves, we've got some very close ties with Chinese partners. And in fact, one of my roles in the firm is to head our China operations. And largely, this came about 10 years ago when more and more of our clients started to ask about the merits of filing an application in China, and we realized there was a need to educate both our staff and clients. So I do travel to China regularly, and I'm keeping on my toes because the IP scene is constantly changing and evolving.
Great, thank you, Rachel. Greg, can you introduce yourself?
Of course. My name is Greg Stark. I'm a partner with Schwegman Lundberg and Wissner. I've been practicing for about 10 years. Primary focus of my practice is patent procurement and client counseling in the areas of due diligence, post-grant review, and freedom to operate type activities. I spend a fair bit of time working very closely with foreign associates as I have a number of large clients, large and medium-sized clients that do quite a bit of foreign filing. And China, of course, has been a big area of focus, particularly over the last few years.
Great. Thank you, Rachel and Greg, for both participating in the program today. Today we're going to talk about patenting in China. I will start by going through some data and looking at some filing trends. Then Rachel will talk about patent acquisition and due diligence. And finally, Greg will address patent enforcement in China. A number of the charts that I'm about to present come from WIPO, and I've included on each slide the source, so if you want to go look at them yourselves, you can. It's important to understand the terminology on these charts because it's a little bit confusing. This is the definition of the terms that are used that comes directly from WIPO. As you would expect, resident is used for filings made by applicants at their home office. So in this case, resident would be the Chinese applicants on the charts that we're about to look at. But I was a little confused at first by the term of abroad and non-resident. In the WIPO database, non-resident is used to identify an instance where an office receives an application filed by a foreigner. So in this case, if we're wanting to see how many U.S. applicants are filing in China, that would be the bars or the numbers marked non-resident on the data that I'm about to show you. And then abroad would indicate how many Chinese applicants are filing outside of China, so abroad is relative to the home office. So let's take a look at the first one. This is application filing trends since 2001. I was a little surprised to see that initially in 2001, the non-residents, so the non-Chinese applicants, outnumbered the resident applicants. Not by a lot, but in 2001, there were a little over 33,000 non-resident applications filed in China and 30,000 resident applications in China. In 2002, that trend continued, although the gap got a little smaller. And finally, in 2003, the resident filings outnumbered the non-Chinese resident filings. Where it really started to be a noticeable difference was in 2006. In 2006, the Chinese Patent Office had 122,000 applications filed by Chinese applicants and 88,000 filed by non-residents. That resident number continued to jump noticeably, as you can see from the bars on this chart, while the non-resident filings have remained fairly level for the last 10 years. In 2015, there were close to 1 million applications filed by Chinese residents and only 133,000 applications filed by non-residents. So I was surprised to see how that stayed fairly level over the last 10 years for the non-resident applications. The next chart is also from WIPO, and it tells us what technology areas those application filings are in. The largest groups are in what I would call computer and electronics. If you look at the light blue colored pie slice, the orange pie slice, and then kind of the gray pie slice, those are about 7% of the filings for digital communications. That's the light blue. The orange is 7% of the filings for electrical machinery, apparatus, and energy. And the gray is about 6% of the filings for computer technology. There's a very big chunk that WIPO has in the category of other. That's almost 50% of the filings. But of the areas where we've got a defined technology area, I would lump those top three together and say that you've got roughly about 20% of the overall filings being in the computer and electronics field, and that's the largest category that we see being filed there. Next, I have some data on the patents granted year by year from 2001 to 2015 from the Chinese Patent Office. I was even more surprised by this data than I was the filings. And this particular data set, again, starting in 2001, there were more patents being granted to non-residents than there were to Chinese residents. And that trend continues all the way through 2008. So in 2001, there were a little over 5,000 patents granted to Chinese residents And in comparison, twice as many, almost 11,000 patents, were granted to non-residents. Like I said, that continued through 2008. Even in 2008, the non-residents had 47,000 patents granted to them, and the Chinese residents had not quite as many. They had 46,000 patents granted to them. So it wasn't until 2009 where the grant statistics show that things flipped and the residents outnumbered the non-residents when it comes to the number of patents granted per year. Now, the other thing that I think is interesting on this chart is if you look from 2009 to 2015, once the residents overtook the non-residents for patent grants, then they really skyrocketed up. You look at how much that changed from 2008 to 2015. We went from 46,000 patents granted to Chinese residents in 2008 up to, about 260,000 patents granted to Chinese residents in 2015. Now, what I think is surprising here as well is the increase, or the non-resident grants did not increase proportionally. In fact, the non-resident grants leveled off and in some cases took a step backwards over that period of time. So in 2008, like I said, there were about 47,000 patents granted to non-residents. By 2015, that had only increased to 95,000, which is a much slower rate of increase than the resident ones. So I found that interesting as well. Next, this data shows the overall number of patents in force in China, regardless of who they were granted to. And clearly, we can see a dramatic increase in the number of patents in force in China over the period from 2007 to 2015. In 2007, there were 270,000 patents in force, and by 2015, there were almost 1.5 million patents in force. And I need to step back here because when Rachel talks in a couple of minutes, she's going to talk about the difference between an invention patent and a utility model. And I forgot to mention that the data that I am looking at is just for invention patents. So this number of patents in force for 2015 is just the number of invention patents in force. And here in just a minute, Rachel will talk about what the difference between those two are. The final slide that I have with data is the top applicants for 2016. The main takeaway from this, as you scan the list of companies there, is that these are all, I think these are all Chinese companies. And certainly the largest applicant really overshadows the rest in a dramatic proportion. So the largest applicant in the Chinese Patent Office in this data is the State Grid Corporation of China. They deal with building and supplying power grids, and they had 15,000 patents granted in 2016. The next one down has only 3,600 patents granted in 2016, and that's the China Petroleum Company. So both companies I find interesting are more in the energy and power field as opposed to computers and electronics, where that pie chart we looked at showed the larger technology areas being more computer and electronics related, although I think they did lump energy into one of those categories that I was looking at. But these top two applicants are more in the power and energy field. So I'm going to turn this over to Rachel now to talk about patent acquisition in China and due diligence.
Thanks, Anne. Yeah, look, there's kind of three main aspects to any IP strategy, and the first one is acquisition. So when you file an application into a particular country, you go before an examination board and you hopefully get a patent at the end of it. So sorry, I'm just moving the slide. The other element, of course, is enforcement once you have your IP rights, and Greg will talk to that. And then, as Anne touched on, due diligence also. A huge number of patents in China, and as such, it would be wise to know what you were going into when you enter into that market. So starting first with acquisition, the first thing I'd say is the Chinese patent system is very new compared to the US system. Look, in fact, the first iteration was only introduced in 1984, and that was quite a big deal. There was much discussion around it because China was growing, and they felt that there was actually a need to be able to copy foreign innovations to be able to fuel that growth. But the government took a different path and sent various delegations across the world to study patent systems. And it's kind of interesting fact that when they all came back and reported, in fact, it was the German patent system that they deemed to be most suitable for their needs. So when you actually go through the process of filing in China, you'll see a very similar model to that when you're prosecuting in Europe. So the question I'm often asked is, why should I bother filing in China? I probably can't enforce my rights, and I run the risk of my invention being copied. And I think all of these are reasonable concerns, and the answer I give will differ depending upon a client's particular business, their market, and their exposure in China. However, I think for any corporation developing a global IP strategy, China usually figures. The sheer size of the market, for one, is attractive to many businesses. And companies have historically found that manufacture in China is necessary from a cost perspective. And so some form of protection is definitely desirable. Look, I also confess I know some war stories, and I'm sure you all do too. But generally, the landscape in China is changing, and more emphasis has been put on innovation rather than manufacturing. It's this kind of move, this shift pushed by Beijing from made in China to invented in China. And from the figures that Anne's just presented to you, you can definitely see that the Chinese are inventing, and they are using the patent system. So, as a result of that, there's definitely an evolving understanding and respect of IP rights, and especially in the kind of major centers such as Beijing and Shanghai. So when you're considering China, and in fact this goes for any jurisdiction or any market you're entering, that's important to your particular businesses, as I mentioned, the three aspects: acquisition, enforcement, and due diligence. So starting here with acquisition, you should know what you can and what you can't protect in China. So this chart is aiming to show, and I actually replaced US, this is for my Australian clients. I think we might need to shrink down the US circle a little bit. The Supreme Court's doing a good job there. But generally, US has a broader reach of what constitutes a patentable invention. So in China, you can get patents for mechanical, medical, computer hardware, software, but with a technical feature, and chemical inventions. And interestingly, in the first round of the first iteration of the Patents Act, pharmaceuticals were actually excluded, but the act was amended in the 90s to introduce that. You can't get business methods, but we face similar limitations in Australia, and I believe it's the same in the US. And a key difference is also there are no methods of treatment and diagnosis, medical treatment, which is similar to most of the world, to be honest. We in Australia can get methods of treatment, and you can in the US. But most other countries don't allow this. There have been some very recent guidelines issued regarding business methods and computer programs, clarifying that per se not patentable, but with the inclusion of technical features, they will now be examined. So historically, what would happen is any kind of claims to business method or computer programs would just be rejected straight away without examination. And now the new guidelines will force an examination for eligibility. So it's seen as a bit of a widening of protection for software inventions. So unlike the US, there's two types of patents available in China. The first is an invention patent, which is akin to the US standard patent. And you'll see there the term of that's 20 years. The second is a lower tier of protection called a utility model. And you might have come across this in some other countries, and particularly Germany. And in fact, Australia has a second tier protection also. I just put something there. Don't forget design applications. We're focusing on patents here, but in the domestic market in China, it's kind of a third, a third, a third. So a third of the filings are invention patents, a third are utility models, and a third are design patents. This slide just gives a brief overview of the differences between a utility model and an invention patent. As I mentioned, the invention patent obviously has a longer term of 20 years, whereas the utility model is limited to a 10-year term from filing. The nice thing about utility models are you can file them, you can, if you satisfy the formalities, you will get it issued. However, if you want to enforce that utility model, you will need to go back to the patent office, and you need to have it examined. The examination bar is a bit lower, so when they're looking at what's in the prior art and comparing it to that, it's generally a bit easier to get a patent for a utility model than it is for the bar for the invention patent. Also, a key thing to note is you can only protect products, so you can't get method claims in a utility model. So moving on to the filing requirements, if you've decided to proceed in China, it's actually pretty straightforward to get an application filed. And you start with having to obviously translate your specification into Chinese. Typically, you would file the translation with your filing documents, but you can, if you need it, get a 2-month grace period to file the translation. And just on the point of translations, I think it's important for everyone to understand there are translations and there's translations. You want to ensure you've got a very good quality translator. You know, going forward, it does add to the expense, but it is important. You are required to file a power of attorney for your attorney in China, and we typically, if we're filing from as a national phase from a PCT, we'll provide a copy of the search report and the search opinion, and we don't translate that, we would just file that. So the next slide moves on to, once you've got those documents ready, you know, what does the process look like? Typically you would, I'm just going to, the top bar there is for an invention patent, and the bottom one is for a utility model. You would typically file a priority application in the US, and then after 12 months you would either file directly into countries of interest to you, or you would file a PCT application. So if you go the PCT route, it's a 30-month country. So you file your application with your translation, your power of attorney into China, and you may request examination at the time of filing. If you don't, there is a 3-year limitation to actually get that request filed. after you request examination, it goes into the queue. And probably 5 to 10 years ago, that was a pretty long queue. The Patent Office has recruited very heavily in the last 5 years, and the time from requesting examination to first examination is now under 2 years on average. So you would typically receive a first examination report, and you may be familiar with this in other countries, and you get an opportunity to file a response. This can go back and forth a few times. Again, there has been a shift here historically. You would have found that your second exam report could have been a final rejection. That doesn't happen so much anymore. And you may get 2 or 3 or even actually sometimes 4. The examiners are quite motivated not to issue a rejection, and that's to do with the point system, that they've had a change there where they're not so rewarded for issuing a final rejection. So you'll find that actually examiners will even phone your attorney and they're trying to move and progress the case along. So that actually has been quite a fundamental shift in dealing with prosecution in China. During the examination, like in other countries, it will be examined under novelty and inventive step. With novelty, it's key to note that a prior oral disclosure or use outside of China is not considered prior art. And the inventive step is similar to the European inventive step and the US obviousness standards. But again, as I mentioned, for utility models, that test is lower. The examiner will also consider in there whether the claims are supported by the description of the application, or if they actually stretch beyond and claim more than is taught by the description. I would note that the bar is quite high in China on this front, and it's been quite tough for many of our clients in chemistry and biotech, where the Patent Office is quite prone to restrict the scope of the claims to the particular working examples. So in those fields where possible, it's advisable to include as much data and examples as possible. Also, China, like Europe, has relatively strict laws around the types of amendments that you can make to your application during prosecution, and any amendment must be strongly supported by the disclosure in your specification. So this slide's pretty rosy. It's showing that it assumes the application will proceed to grant, and in reality, as we all know, sometimes examiners don't play ball and they decide to refuse the application. So if it is refused, your options at this stage are to either file a divisional application and have another crack at it, hopefully with a more understanding examiner, or you can appeal the decision to the board within a 3-month period of that rejection. And you can seek a re-examination. And then a panel formed by the board will re-examine the application. This second bar here just shows the process for utility. I'll just jump back actually. So the time frame on the invention patents around 3 to 4 years from filing. Utility model, again, you can use your US priority application, and within 12 months you can, or 30 months, you can file your utility model. If you're wanting to use a dual system and you want to file in China a patent, an invention patent and a utility model, it's important that they're both filed on the same day. So you should be filing a utility model if you want to use that for that invention when you file your PCT, or the 12-month stage for your invention patent. And you'll see it's much quicker. It's typically 6 to 10 months from filing to grant. And again, that's because there is not a kind of substantive examination there. It's more satisfying formalities requirements. But if you do want to enforce that further down the track, you will need to go back to the examiner and have it examined. this is 2012 data. You saw the 2015 data. It's pretty clear there's lots of patents in China. And if you have gone to the expense to gear up to get ready to enter that market, might have I worked a lot in medical devices, you might have got your regulatory approval. The very last thing you want to do is enter into the market and face a block by a patent there. So factor in that it is possible to get sued in China. The sheer vast number would suggest there's plenty of patents to rely on, and it has happened. How do you address this? I think if you are serious about that as a market for your business, you should be conducting a freedom to operate search. And the literature is vast, it's huge, but it's certainly worth doing to avoid any surprises down the track. If you do find pertinent patents, then there is an opportunity at that stage to request an invalidation before the Chinese Patent Office. So kind of knocking them out before you get to the point of there being a real problem. This slide is just to demonstrate again, if you're thinking about an international patent strategy, where does China fit? You know, the market size in the US is huge. For most of my clients in medical devices, that is the key market. Europe, again, a very large market size. Unfortunately, in Australia, we're quite small, but we like to think sophisticated. New Zealand, even smaller. But when we look at China, realistically, the market size is very compelling. So knowing that the market's so large, it is definitely worth spending a bit of time and effort looking at how you're going to secure your IP over there. There we go.
Thank you, Rachel.
And now, yes, sorry.
Oh, go ahead. Did you have more? I'm sorry.
No, I was just going to hand over to Greg.
Perfect. Yes, Greg, can you talk about enforcement?
I would be happy to. Thank you, Rachel. That was great. Yeah, and interestingly, as we walk through this, it's really interesting to see how enforcement in China has changed and sort of rapidly matured. You know, as Rachel mentioned, the entire patent system within China is really quite young, particularly in comparison to U.S. or European standards. Also, as Rachel mentioned, we'll see as we go through enforcement that China has absolutely modeled their enforcement regime after Germany, where they have a bifurcated system, that splits infringement from invalidity determinations. Just a couple. So I think the first question here, and I think Rachel touched on this as well, is sort of why in a patent strategy are we talking about enforcement? And I think enforcement is obviously very critical. It's very key to determine within any jurisdiction, whether there is a viable enforcement path for your intellectual property. And if there's not, obviously that intellectual property has a much lower value. And I think China is an interesting study in that, I think historically, many of us U.S. practitioners in particular, I think, have operated under the impression, maybe not so much in the recent years, but certainly a decade ago, that there wasn't much of an enforcement regime in China, and that it was not something that was, that you were really getting patents sort of betting on the future. And I'd like to say that I guess from what we're seeing and what we're hearing from our foreign associates, that the future's really come, and that patent enforcement is a very viable activity within China, and it is fast. It is relatively low cost, particularly in view of the U.S. And it's a fairly pro-patentee environment, as noted here. It's also an environment where a foreign entity can, actually enforce their rights. I think historically China's been thought of as being, fairly biased to their local businesses and such, and the statistics just aren't bearing that out any longer. And then, so sort of stepping back from the basics of enforcement, and I move on to the next slide here. So the enforcement system the enforcement system, in China really has a couple different venues that you can look to enforce your rights in. These three venues that are shown here are really trying to sort of summarize, for all of the IP, including soft IP, and criminal enforcement, realistically is really, not something that you're going to look to for patents. It's really only applicable to false marking claims. So taking that one off the table, you're really looking towards either a judicial, civil court action, which is going to be fairly similar to what you would do in the US or Europe, or an administrative action. The interesting aspect of the administrative action is that it can be an extremely fast process. It's very low cost, and you can get an immediate injunction. The obvious downside is that there is no mechanism within the administrative action to sort of enforce or compel, any sort of damages or monetary compensation. The administrative bodies in China also have, a relative inability to handle particularly complex cases. Simple patent cases, particularly utility models, are often enforced through this avenue, from our understanding. But a challenging or complex invention model is probably not the route you're going to take. And most of the discussion, following discussion, is really going to focus on civil court action, which the slide here says unlimited compensation. While I think technically that's probably true in China these days, the reality is that there is still a statutory damages regime, and the damages on average are probably going to be a fair bit lower than what you would find certainly in the US, and even probably in comparison to the European practice. Again, the high cost and the time consuming here is really in reference to administrative actions. If you look at those numbers in comparison to typical US litigation, the numbers are actually extraordinarily low. So again, as I mentioned at the onset, the enforcement regime in China has been modeled after the German model of a bifurcated system. So infringement will be decided, in a civil court, or if you go through an administrative action, it would be by the administrative body. And then invalidity, if it's going to be challenged, which it almost certainly will be, that is done outside the court case within the state intellectual property office. So typical time frame for a court case, they can be decided in 6 to 12 months unless they're stayed, once the court accepts the case. Stays are a possibility in China, and probably becoming more common as invalidity assertions become more sophisticated. But it is not a guarantee. There is no certainty that you're going to get a stay. The court will look at your invalidity petition and will look at the evidence and the arguments presented from the other side to make a determination, as to whether a stay is warranted. But as in any litigation, stays are reasonably common, probably becoming more common, and any sort of delay tactic for the defense is probably going to be pursued with some vigor. So in talking about invalidation, invalidation within the is again done within the state intellectual property office. invalidation rates, as Rachel mentioned, the utility model is, I guess, considered a lower level or lower tier of patent. But in reality, once you're in the enforcement context, the utility model, other than having slightly higher invalidity rates within the enforcement regime, the utility model is just as powerful as an invention patent once you have it in a position to enforce. So don't discount, I guess, is the message there, the use of and the opportunity to obtain utility models. I know from a U.S. practitioner perspective, it's not something that, because we don't have an analogous device here in the U.S., I think it's something we typically don't think about as often. But anyway, something to think about. Getting back to the invalidation timeline, the invalidation timeline in China is relatively quick. Once you file the petition, you have 1 month to file evidence and basically all of your arguments for invalidity. So advanced preparation is quite critical here, especially in the view of that the Intellectual Property Office in China has very strict rules about the evidence, and that it must be what they would call official evidence. And I guess the view there, the sort of the little bit of a story about how stringent this is, that a foreign associate has enjoyed sharing with me, is the idea is, if here in the U.S., if we get a printed publication, for example, that's come from some known journal, and it has a publication date, and you can go to a library and grab a copy, and that's going to be sufficient. In China, that same piece of evidence can be made sufficient, but you have to go through some process in order to validate it for the office, which may involve actually going to a library with a notary and having the notary notarize a copy as the librarian looks up that that journal article in the library. So the official evidence aspect is something where particularly foreign practitioners driving an invalidity thing can get tripped up. So it's something to keep in mind. The other thing to keep in mind is that claim amendments are allowed, but they're very restrictive. So they're limited to claim combinations or deletions. You really can't go back to the specification looking for additional features. In reality, this is probably not dissimilar to the IPR context in the U.S. these days, where amendments are certainly going to be limited. You might be able to go to the specification for them, but it's not a wide open field for sure. So moving on here. There we go. Oh, sorry about that. Damages. I think this is an area where China has seen some very interesting developments really in the last 7 to 8 years. And I think the other thing that's very interesting about some of the developments in the damages area is that it corresponds quite interestingly to a lot of the filing and grant statistics, where this Clint versus Schneider case actually got decided in 2007, and it was the first really quite large damages determination, where there was a 330 million RMB decision against Schneider for infringement of a patent. It's really the first case first big case in China that was very widely publicized, where clearly lost profits came into the damages compensation. And I think it's interesting how the timing of that case and my understanding of the wide publicity around that case corresponds very interestingly with resident both filing and grant statistics sort of dramatically rising in that 2007 timeframe. So, what these recent trends really tell us is that, yes, there is still a statutory damages regime where, you know, I don't even know, I guess I don't know statistically whether it's the majority of cases, but I believe that it is still the majority of the cases that are, are receiving, more something along the lines of statutory damages. But these more recent cases definitely show that with the right evidence and with the right litigation strategy, that you can get compensated for your actual losses around infringement of intellectual property in China. I think the other interesting thing is that I believe it was around the same time frame as the Snyder case. There was a change in the law in China where attorney fees awards are basically statutory. So as long as you can prove your attorney fees, you can recover them as a plaintiff if you win. So I think to wrap up here on the enforcement, I think the big takeaways are that China has become, at least statistically, a very pro-patentee jurisdiction. China offers a fairly fast route to disposition, and certainly if you're looking for an injunction and that's your real goal, an administrative action can potentially get you an injunction within 6-9 months, not unrealistically. Venue, I think certainly from a strategy perspective, choosing venue is a real critical decision. I think one interesting aspect of the administrative action is that it does not actually foreclose later enforcement via civil litigation. So if you want to seek a quick injunction, you could do that through the administrative action route, and then later still go to court to seek damages. Finally, evidence, particularly in the invalidation context, is something to be, very mindful of. Well, Anne, why don't we open it up for questions?
Great. And actually, before we jump into the questions, I want to remind the audience that you can submit questions using the question button on the right-hand side of your browser. While we're waiting to give people a minute to enter questions, I wanted to briefly review what we talked about. So I showed some data that indicates that the number of Chinese applications has increased dramatically, and also the grants to Chinese residents has increased dramatically over the last 10 years. I think that reflects the emphasis on innovation in China and the growing recognition of intellectual property in China. And with over 1.5 million invention patents enforced in China, there's quite a bit of intellectual property there, and that's growing. Rachel explained the size of the market in China makes it desirable for foreign companies, and with the changing IP environment in China, it's worth considering as part of your IP strategy. One notable difference between the U.S. system and the Chinese system that Rachel explained is the invention model patent, which is a lower tier patent that isn't initially examined, which we really don't have a counterpart to in our U.S. practice. And she also noted that the growing number of patents in force is something you should take note of and make sure you do your due diligence before entering the Chinese market to protect yourself. And then Greg talked about the enforcement in China, and that the enforcement in China has rapidly changed and matured. The enforcement procedures are modeled on the German procedures, and the process is relatively fast, relatively low cost, and tends to be relatively pro-patent. So with that, we have a couple questions that have been entered. The first one, Rachel, I'm going to direct this to you. It's directed to the Australian speaker. The Australian speaker mentioned that for utility model patents, if you want to enforce it, you would have to go back and get a substantive examination. Can you provide more details on what's involved in that? High-level time, cost, or likelihood of success. Any comments on that, Rachel?
Yeah, sure. It kind of goes back into the system like you would go through for the invention patent. So it's a request for examination that goes to the Chinese examiner. It's slightly quicker. It's less than that 2 years that I suggested was average for invention patents. But it will go through a review on novelty, inventive step, support of the claims. But as I mentioned, the bar is a little bit lower there. So what the examiner can reach back to for prior art is slightly more limited. Therefore, to answer that, likelihood of getting it granted is higher because of that. But it could still be rejected, in which case it goes into a re-examination system, much like the invention patent.
Okay, thanks, Rachel. The second question in the queue is, what kind of evidence can be used in China? Worldwide patents and publications, worldwide products, worldwide product literature and brochures. Rachel, do you have any comment on the scope of, they say evidence, I'm assuming that means prior art.
Yeah, for the prior art, it's any publications, written publications around the world. But I noted that it's a slightly different process in China. Is that if somebody has used or publicly, verbally, orally disclosed an invention outside of China, that doesn't constitute a prior disclosure, prior art.
Oh, that's interesting. That's good to know. Thank you. The next question is, what is the breakdown of resident versus non-resident in success of enforcement? Favorable judgments or orders for residents versus non-residents? Greg or Rachel, did either of you have any data on that broke down enforcement by success for residents versus non-residents?
So, a couple of the articles that I uncovered for, in preparation for this did have, some statistics on this, and basically within, I think the article that had the best sort of recent statistics, those statistics suggested that there's really only a slight difference in success statistics for non-residents versus residents, and the article didn't really go here, but based on some other research and some other thoughts as far as those statistics go, part of that statistical difference probably is attributable to a difference in how strong the patent was to begin with. I know non-residents, if you haven't gotten a great translation, often the IP is starting from a non-Chinese, reference point, where, on the resident side, the IP is often, just the opposite, and, the general wisdom is that has an effect statistically on the strength of the patents.
Rachel, anything else to add to that?
Yeah, I agree with Greg. The stats I had, they're a little bit old, I think, but for plaintiff win rates, it was about 81% for the resident, 75% foreigner. Defendants win rate, actually the foreigners, the non-residents were doing better, with 62%, and the local 19%. So that data is about 5 years old, and it could have changed. But I think it's evidence that it's not so skewed against foreigners when you're a plaintiff, and actually foreigners do pretty well in the defendant win rate.
And Rachel, I think the data that I was looking at was probably relatively similar. I think it was 2012, and the statistics were nearly identical, if I recall correctly, to what you just suggested.
Okay. One additional question. Is there any data for resident government-sponsored versus non-sponsored? I have not seen the data broken out that way. Have either of you Rachel or Greg?
I have not seen that data. No, I'm not sure whether they published that. So it'd be interesting, though.
It would.
Whether maybe Greg has seen it.
And none of the articles I've looked at recently anyway, had any breakouts that way. But I agree it would be potentially interesting.
Yeah, and I certainly didn't see it in the filing or the grant data that I looked at, unfortunately. So, but maybe that is something in the future they'll start to track. Well, today we've talked about the various aspects of patenting in China. We will post the slides and the audio recording of today's program on the Black Hills IP website. So if you go to our educational materials menu, there's a Foreign Excellence submenu, and it will be posted under those. We have some contact information here. If you're interested in more information about Black Hills IP, please contact our Vice President of Sales, Jim Brophy. If you would like more information about the SLW Institute, please contact Brian Ness. And then I want to just note the next program in this series will focus on patenting in Japan. That will be presented on Thursday, November 30th at 1 p.m. Central. And you can register for that on the Black Hills IP website as well. So thank you everyone for participating today, and Greg and Rachel, thank you so much for your insights. I really appreciate it. We hope you will join us for this and future webinars in the Foreign Excellence webinar series. Thank you.